Welcome to Impact OC, the only program showcasing the people and organizations shaping Orange County. With your host, Don Camber.
Hello, live from the OC Talk Radio studios at UCI's Beal Applied Innovation Center. I'm OC Talk Radio Public Affairs Director Don Camber with another great guest impacting our community in a positive way. April is Fair Housing Month. Today, I welcome Fair Housing Council of Orange County Program Specialist David Levy. Under the direction of a volunteer board of directors and staff, the agency works to fulfill a mission of protecting by ensuring equal access to housing opportunities, fostering diversity, and preserving dignity and human rights. Thank you, David, for being on Impact OC.
Thank you, Don. Before we get started today in our conversation, I'd just like to let people know why April is Fair Housing Month. Today, April 4th, unfortunately, is the 55th anniversary of the murder of Dr. Martin Luther King Jr. And the Fair Housing Act was enacted 7 days after that horrible act. His death actually was the impetus to get that law across the finish line. It had kind of been stalled out in Congress. And of course, with his death, we were able to get the Fair Housing Act put in place. But sadly, 55 years later, we still have to deal with housing discrimination.
Well, David, what are some of the problems your clients face in getting access to housing opportunities?
Well, I'd say in terms of overall access, and especially true here in Orange County, a major factor in access is just affordability. The high price of housing is really putting people under a lot of strain and struggle. People are having a hard time finding housing that they can actually qualify for and afford. And of course, that is on top of possible acts of discrimination that might be keeping them from accessing housing.
And what are the forms of discrimination?
Well, there are two basic ideas of discrimination. One is differential treatment. That's where, on the basis of one of the prohibited bases or protected classes under the law, someone is treated differently. They could be outright denied the housing, or they could be given different terms and conditions. They might be asked to pay a higher rent, or they might have to pay a higher security deposit on one of those bases. So that's a number of things: bad services, failure to make repairs, that sort of thing. But there's also another aspect to housing discrimination. It's called disparate impact or discriminatory effects. And that's a situation where a housing provider might have a policy which, at least on its face, appears neutral. Everybody in theory is being treated the same, but it has a disparate impact or discriminatory effect on a particular group that might otherwise be protected under the law. An example I like to give in that context is perhaps occupancy restrictions. Familial status or families with children in the household under the age of 18 are protected under the law. But if you have an overly restrictive occupancy restriction, for instance, it's something that might be as absurd as you got to have only one person per bedroom, well, that's going to deny people with families from having access to housing. So that's the idea of a disparate impact or discriminatory effects. It's not something that's intentional, although I often suspect that some of these policies that are supposedly facially neutral are constructed with an intent. But the idea is if people are discriminated against, it's still discrimination, even if there was no intention.
What are some of the protected classes?
Well, the federal law enacted, like I say, we're coming up on the 55th anniversary. When it was first put into place, the first four protected classes, or I prefer the term prohibited bases. The reason for that is protected classes to me implies that some people are protected and others are not. And in fact, all of us are protected by fair housing laws. But the prohibited bases that were the part of the original law were race, color, religion, and national origin. And that was in line with what was happening in civil rights laws generally at that time in the late 60s, mid to late 60s. And then the federal law has been expanded since then to include sex, and more recently, although not so long, quite a while ago really, in 1988, disability and familial status was added. But California has a history of going beyond the federal law. So in California, we have other prohibited bases. We have sexual orientation, gender identity and expression, marital status, source of income. Even under some aspects of California law, there's a concept of arbitrary discrimination where it's not under the Fair Housing Law, it's under something called the Unruh Civil Rights Act. But if you don't have a good cause business reason for treating people differently, then you may be discriminating as well.
So how does it exist and where?
Well, housing discrimination sadly has been with us a long time and continues to be. I would say that, again, one of the things, what we do is in our agency in trying to detect a fair housing violation is we send out people that we call testers. We send out a paired group of people. They're given a profile. They're essentially actors. They're asked to perform a role, if you will, to stick to a profile, go do a simulated housing transaction, and write an objective report. They're not told why they're going to the property. And what happens is one person will go and they'll go through the transaction, simulated transaction, and then another person may go in and do the same thing, maybe 20 minutes, 30 minutes later. And then we compare those reports. And what we'll see is, for instance, what we would call the protected tester, as opposed to the control tester. They're told, sorry, we don't have any vacancies available at the present time. If you'd like to fill out an interest card, we can get in touch with you if something comes available. And that person leaves, and then the so-called control tester will come in, and lo and behold, suddenly there are 2 vacant apartments to be seen. And when that happens, we suspect that there was an act of discrimination where there was a denial of available housing, and that's one of the things that we can often detect. But it's sometimes discrimination can be much more subtle than that, and what we often refer to it now is discrimination with a smile. It's not the days of overt discrimination where somebody just said, well, we won't rent to your kind of thing, because they know that they can be held accountable for just making such a statement as a violation of fair housing law. Even if you ultimately chose to rent to the individual, if you made a statement that was discouraging or discriminatory, that in itself is a violation. So people are much more subtle in their acts of discrimination, but they can erect various barriers that make it harder for the people that they want to exclude to have access to the housing.
What prompts you to do these test cases?
Well, we have two reasons for doing our testing. One is based on complaints that we might receive from people. People do call us and say, I think I've been discriminated against, or they may relay a transaction they're not knowing or thinking that they've been discriminated against, but they're telling us a story that we have to be careful not to lead them into saying they've been discriminated against, but at the same time they tell us a story that leads us to believe, well, this might involve discrimination. And so we will then go and do a test on the basis of their complaint. If they say, I think I was discriminated against based on my race, then we'll send out 2 testers, one of the racial background of the person who feels they were discriminated against, and then the control tester will typically be a white individual, and we'll do the test there. But the other thing we do is we do systemic testing. We have grant from the U.S. Department of Housing and Urban Development, HUD, to do what's called private enforcement, the Private Enforcement Initiative under the FIP program, which is the Fair Housing Initiatives program. And so we do systemic testing where we'll choose properties, not necessarily because we've suspected discrimination, but we're checking what's going on in the community, and we'll send out testers and again see if the individuals who are offering the housing are doing anything that might be construed to be discriminatory.
When you find that out, what happens?
Well, once we have evidence of discrimination, then the remedies available to someone who's either been the victim, the bona fide victim as we call them, or in the case of the systemic testing, the agency itself has standing, it's called organizational standing. We can file a complaint with the government. Most often we do that with the Fair Housing and Equal Opportunity Office of HUD, or we might, if it's a state basis, if it's, let's say, sexual orientation, which has not been explicitly covered under federal law, and I'll get to that in a minute, we would file it with what is now called the California Civil Rights Department. It used to be called the Department of Fair Employment and Housing, but last July they changed their name. So that's what's called an administrative complaint, but there's also the ability to file a complaint at court, either in state court or federal court, again, depending on the basis that the complaint might be brought.
Well, and then when there is that complaint, what happens to the person who the complaint was filed against?
Well, they'll be usually in the complaint process, especially in the administrative process, there's an attempt at what's usually called conciliation or mediation, where the parties are brought together with a neutral party and the facts are brought out, and hopefully the evidence would support a claim of discrimination, and so the party who's been accused of it will make a settlement. And so usually in those settlements, of course, it's the standard recitation that there's no admission of wrongdoing or guilt, but at the same time they might wind up writing a check. and taking other actions such as getting fair housing training. That's one of the things our agency is able to offer, is that housing providers can keep themselves out of trouble by getting training on what the fair housing law is and how to avoid discrimination, especially, as I mentioned, the discriminatory effects form of discrimination. They may not realize that they're acting in a way that could be construed as violating fair housing law, so we can do the training. There may be injunctive relief, which is where the party is ordered to do something or not do something. An example I like to cite in training is, let's say it was a discrimination against families with children. Maybe there would be an agreement or an order, even depending on how this is being worked out, that they put a tot lot or play lot onto the property to make the property more welcoming to families with children, but they were previously trying to exclude them. So those are the kind of things. And of course, then there's monetary damages. People can be given compensation for being a victim of housing discrimination, and there can be, in certain instances, punitive damages, which is intended to punish the wrongdoer in addition to those that are intended to compensate the victim.
What are some of the things that people are doing that could be construed as discrimination and they don't know it?
I think certainly, well, I think not knowing it is partly a result of training. Now, half of all housing discrimination complaints are brought on the basis of disability. And one of the areas of discrimination on the basis of disability is the failure to properly provide a reasonable accommodation to someone who's disabled. The concept of reasonable accommodation is that a housing provider will change the way they do business. They'll change their policies, practices, or procedures because it's necessary for a person with disability to be able to use and enjoy the housing in the same manner as a non-disabled person. An example, and a very frequent example we get at that, is people who need an assistance animal. A housing provider under regular landlord-tenant law can say we do not allow animals, do not allow pets, or they can put restrictions on the types of pets or animals that they're willing to allow. But if a person has a disability-related need for an assistance animal, then the housing provider would have to modify that policy to allow the animal. The classic example, of course, is somebody who may have a vision impairment and they have a guide dog, but there are many other instances in which a disability might benefit from the presence of an assistance animal, and even what is often referred to as an emotional support animal or a companion animal, where the animal provides the benefit simply by being itself. It's not specially trained to perform any task or do anything beyond being itself. And most often that's in the case of someone who may have a mental disability. They may have a form of anxiety or depression that would be considered a disabling condition, and they benefit from having the assistance animal. So the housing provider would have to allow that to happen. Well, the law says when you grant a reasonable accommodation, you cannot require any financial burden on the person making the request. So you can't have a so-called pet deposit or pet rent if someone has an assistance animal. Or if they're asking for a parking accommodation, which is another common one that we get. Somebody might need a closer parking space or a wider parking space because of their physical disability. You can't say, well, yeah, I'll grant you that accommodation, but you're going to have to pay $25 a month extra to get that parking space that you need. So I think reasonable accommodation is an area in which there's mistakes being made. People don't take the process seriously. They don't respond to requests appropriately. And so that's an area that I think is, as I mentioned earlier, over 50% of all complaints are based on disability. The other area of disability discrimination that's covered by the law, besides just outright discriminating because someone is disabled, which is the same as if you were discriminating against them because of their race or their national origin. But the other area is what's called reasonable modification, where someone needs to actually change the physical characteristics of the property. And again, landlords often get it wrong in terms of denying someone the opportunity to do that. Usually it is the disabled person themselves that has to pay the cost of making those changes. Only in the case of a property that's got federal dollars involved does the housing provider actually have to pay the cost of the modification. So those are some examples.
So what can be done about discrimination?
Well, I guess the simple answer would be to stop doing it, right? I mean, but in terms of avoiding discrimination, one is to have an educated housing provider community so that they understand the law and follow it, and understand that there are severe consequences if they don't follow it. And then the other side of it would be to have an educated housing consumer community, that they understand that they have these rights that have been afforded them for over half a century now, and to know that when they suspect that they've had those rights violated, to get in touch with an agency such as ours, or go directly to a government enforcement agency, the California Department of Civil Rights, or the Fair Housing Equal Opportunity Office of HUD, and they can make those complaints online to the government agencies. We can help them navigate that process, and because of our connections to the government agencies, we can perhaps expedite to make the process more streamlined and less frustrating, because it can be frustrating at times. It is not a fast process, unfortunately. It takes a while for a complaint to be taken in and processed. The agencies, even though only 2%, it's estimated only 2% of fair housing violations are ever reported to an agency such as ours or to the government across the country in a year. The total number of those such complaints that are documented may be in the range of 20,000, but that's only 2% is the estimate that's out there. So that would imply that there are actually 1 million acts of housing discrimination that occur in the country every year, using that estimate. And it's, in part, people don't make the complaint because they either don't know how to, or they've got other things on their mind. You know, they need, if they've been discriminated in finding housing, rather than take their time to make a complaint about that, they move on and go look for housing somewhere else. So what can be done about it is to make people more aware that it's against the law, and that there's a remedy if the law does get violated.
And you provide education on this.
We do. We do community workshops. We have grants from local government as well as from HUD, and we provide workshops in the community to educate housing consumers and also housing providers. And the other thing we sometimes do is, as a result of a settlement of a fair housing complaint, we will provide training to an organization that's been mandated to receive that training, often under what's called a consent decree settlement of the case. And so that consent decree might say for the next 3 years, the staff of that organization must receive annual fair housing training. But we also offer that training without someone having been caught doing something improper. And yeah, a good way to avoid getting caught up in a fair housing complaint is to be educated about the law and learn how to follow it. And to know when to, if you have a question, know when to reach out and ask that question to avoid problems.
What are some of the signs of discrimination that would-be tenants don't know about?
Well, again, I mentioned discrimination with a smile, and it's hard to tweeze these things out sometimes, because landlord-tenant law in itself can be complex, and tenants can feel that they're being mistreated or treated badly just because the landlord feels that they have the power over the tenant. But the question is, does it go to a motive that is a violation of fair housing law? That's the key. There are interpersonal conflicts where some housing provider or manager just doesn't like somebody else, and it's not based on a motive that would be considered discrimination. And that particular type of conduct, unless it's specific in nature to reach the point of being so-called illegal harassment, is not actually illegal. It's not good business practice per se, but if a manager just doesn't like somebody else and treats them badly because of it, and there's no discriminatory motive behind that, sadly not much to be done in that situation. So yeah, it's hard to sometimes distinguish for a tenant, and that's why, like I think I said earlier, people contact us and they tell us a story, and we're very careful not to lead them into saying, oh, well, you've been discriminated against, because we want them to tell their story, and then based on our knowledge of what might be at play here, then we could say, well, you know, have you ever considered the possibility that this was based on your race or your national origin or your disability, and have them come to that realization if they think it's the case. And in some cases they say, no, I don't think that was it. You know, this manager just doesn't like me. And if that's the case, then it's not a fair housing case.
How are you funded?
Well, we get funding from, I mentioned earlier, we have a Fair Housing Initiatives Program grant from HUD to do the Private Enforcement Initiative. We have another grant from HUD to do what's called an Education and Outreach initiative. And part of what I'm doing here today is an outreach and educational activity that we will report back to HUD as we were able to do as part of receiving that grant funding. But we also get funding from local governments from what's called the Community Development Block Grant Fund. I think I mentioned earlier the idea of affirmatively furthering fair housing. and federal recipients of funding need to take actions to do that. So the recipients of these community development block grant federal funds have to certify back to HUD when they get that money that they are taking actions to do the affirmatively furthering fair housing at work. And by contracting with our agency to provide our services, that's part of what allows them to do that certification. So we currently have grants from 7 different jurisdictions in Orange County, including the county, which covers all of the smaller cities. So we serve about half of the county population currently under those grants.
Thank you, Fair Housing Council of Orange County Program Specialist David Levy, for being on Impact OC. And I thank everyone for tuning in. I'm OC Talk Radio Public Affairs Director Dawn Camber. Have an impactful day.
You've been listening to Impact OC, the only program showcasing the people and organizations shaping our community. Right here on Orange County's only community radio station, OC Talk Radio.